good morning, and good afternoon to in-house counsel from all across North America and sometimes the world. Welcome to In-House Connect. My name is Shai Mahani, and I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your lunchtime or your breakfast time with us, and special thanks to our wonderful sponsor, Structure Law Group, and our fantastic presenters today, Robin Ratner and Johanna Manan, for putting together a fantastic presentation on how to draft a fail-proof settlement agreement. For those of you here for the first time, let me give you a quick bit of background. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect will organize free CLE classes, which are hosted by different law firms, and every 6 months, we would organize fun and festive cocktail networking receptions. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then, of course, COVID hit. We couldn't meet in person, so we went online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel, truly from coast to coast, and we've been able to feature high caliber speakers like the two we have today, who I'm going to introduce in just a few moments. This is our 31st event of the year so far, and I'm wondering, are you here for the first time, or have you attended one of our events before? I can't see the polls. I'm flying blind here. Robin, what percentage are new?
All right, new, we have 12%.
Okay, interesting.
Between 5 and 10 events, 13%. So those two are close. Attended between 2 and 5 events is 28%.
Okay.
No, I've attended one event previously. That's 18%. And
I guess yes is
28%. So hopefully that adds up to 100.
Yeah, I went to law school to avoid math. We'll round up. So 30% are new. Welcome to the 30%, and hello again to the 70%. Great to have you with us today. Okay, no more housekeeping announcements. Let's get into today's event. Settlement agreements for in-house counsel, key steps and best practices to draft a fail-proof settlement agreement. Our presenters today are Robin Ratner and Johanna Manan. Robin is an experienced business practitioner and trial attorney with an emphasis in financial business disputes, institutional lender disputes, and real estate matters. Robin began her practice at Century City Law Firm, representing clients in a broad range of matters, including commercial and residential real estate disputes. She has also negotiated commercial leases and contracts for Fortune 500 companies and international e-commerce companies. Robin's experience and focus includes complex accounting matters regarding business disputes for corporate and partnership clients. Our next panelist is Johanna Manan. Johanna's practice broadly encompasses all aspects of corporate and business law, with a focus on business formation, entity restructuring, corporate governance, and compliance, private securities offerings, equity financings, and mergers and acquisitions. Johanna also handles commercial and real estate transactions and advises companies on general business matters. We are so fortunate to have such experienced practitioners like Johanna and Robin on with us today, teach us how to draft fail-proof settlement agreements. So with that, I'll turn things over to Johanna to get us started.
Thank you, Shay. Good morning and good afternoon for those on the East Coast. Well, thank you for the introduction. And yes, we wanted to talk about settlement agreements today because most attorneys encounter settlement agreements in their career, no matter the practice area. So very often you have this dispute, lengthy negotiation, and then finally you reach a settlement. Some people may be tempted to rush the settlement agreement, but it's actually the most important document because it will cut exposure to liability. So there's no boilerplate settlement agreement. And for best practice, every settlement agreement should be specifically crafted for the actual set for the relevant settlement. And so first we wanted to do a poll here and want to know when is the last time you or your organization has updated your template settlement agreements. So if you want to take the poll, and that would be, I think, Robin, you can run it. But 30% updated their template last year, and 40% cannot remember. So 20% in the last 2 years and 12% more than 3 years ago. So I guess it's a great topic. And a lot of you will find it hopefully interesting, and we'll try to do a good job in highlighting important aspect of a settlement agreement and giving you as many tips as possible. So the first part, our presentation, will be a checklist for a settlement agreement in the outline, and I'll just go over like the important part of the settlement agreement, the skeleton. So number one, of course, would be the parties. Make sure to define them properly. The second term is like the payment terms and consideration or the obligations. So for best practice, don't just write the settlement amount. You really want to give the specifics of when the payment will be made, what is the exact amount, how it will be made, by check, by wire transfer. You want to consider if your client is the party making the payment, consider the timing to obtain the approval to disburse the funds. Also, if you have installment payments that are part of the settlement, then you really want to try to spell out when these will be made and what is the exact amount. Is there a grace period if the payment is late? Just give some verbiage there so that it gives the parties more clarity as to what they have to do. Also, you may want to make sure to write down every other performance or any other obligations. So if the other party has to perform or do something specific, you want to spell it out. If there are any transferring or releasing of property, returning some goods, dismissing a lawsuit, anything that is part of the consideration for the settlement agreement should be as detailed as possible. Because keep in mind that if the other side does not perform on their obligation, then you will be entitled, you can suspend your own. And that would be easier for you to suspend your performance than having to go after like a breach of contract because they're not performing their obligation of the settlement agreement. So that gives clarity and more visibility for all the parties. And also, once you have a default provision in your settlement agreement, it's like more ascertainable which aspect is a default, which one is material, which one is curable, and so on. So you want to not rush into that part, and payment terms and consideration should be as specific as they can be. The second part is the gist of the settlement agreement, and that would be the release. This also should the counsel then should really pay attention to this section of the settlement agreement. You want to make sure to identify the releasing party or parties and the released parties. So most of you are in-house counsel, so I assume working for representing a company, most likely you have subsidiaries or affiliated entities. To the extent it's applicable, you may want to include them in the list of the released parties. On the other hand, if you're actually on the claimant side, you may want to limit and not include and actually specifically exclude parties not involved that may want to bring a claim later on. Also, in terms of the release, you have a specific release, you have general release. So you want to determine what kind of release the settlement agreement will have. Is it going to be specific, meaning that limited to claims described in the agreement, often in the recitals? And in that case, you want to have an express reservation of rights to bring claims later on. On the other hand, if you want a general release, meaning that not only the claims asserted in the pending dispute will be released, but also potential claim contemplated by the parties, then you may consider if, first you may want to specify that it is a general release, but you also want to consider if that would include unknown claims. Based on the jurisdiction in which you are, you may need a specific waiver for this. And what I mean by this is, for example, so we're in California. In California, we have this Civil Code section 1542 that says that a general release does not extend to and does not include unknown claims. So if we want to waive and if we want to release these unknown claims, we need to have a specific waiver of that code section. And it's so sensitive that I've seen in agreements that specific waiver and that code section being specifically waived in bold and have the person releasing the releasing party include their initials right after that provision to make sure that they have read it, they have understood it, and they're knowingly waiving it. So also, if you're in California, you may want to check that section, and because it has been updated in January 2019. So if you have updated your settlement agreement template before that, you may want to revise that particular language. And so once you know if you want to have a specific release, general release, if it will include unknown claims, think also if the release will be mutual or only one way. Again, there are different ramifications for that, and it's better practice to spell out exactly the nature and the scope of the release. Another important paragraph would be the conditions. Are the obligations of the party, will they be conditioned on the other party performing? So often the releasor will want the release to be effective upon the full payment, and the releasee will want it to be effective upon the execution. If you're not confident, or if you have doubts, or you have concerns that the other side may not perform their obligation, then you want to specify and make sure that your own obligation or the release will be conditioned on them performing their obligations. So it could be the payment. The condition could be payment, full or partial, could be the dismissal of the proceedings, delivery of the goods. In terms of payment, you want to specify, maybe it could be like if it's installment payments, is the release effective on the last payment or on the first payment? So these are like all type of considerations that you really want to give it some thought and include it there, because I've dealt with people where we are reaching an agreement, but because they were already flaky or they have already breached their prior agreement, and that's why we end up here, we're not that confident that they will actually perform their obligation under the settlement agreement. They have already breached prior obligations, so might do that as well. So this is one way that I was protecting some clients, is by making very strong condition clauses that just give some, not assurances, but it will give my clients the peace of mind that they may not have to perform because the other party does not perform. Also, so that's for condition, and it's one important. Sometimes we tend to omit it, but if we want to craft the agreement and we want to craft the obligation of the parties based on conditions, we can spend quite some time on it. It's worth it.
So Hannah, may I ask you, do you recommend in talking about conditions, if there's special conditions, whether it's structured payment or additional forms that have to be recorded, do you recommend separate provisions initialed or signed by the parties for all conditions, or it's not necessary? What's your general thought on it?
Well, you can list the documents, for example, that must be filed. And if these agreements have not been finalized, you can agree as to a form and then maybe attach it as an exhibit to the settlement agreement, saying something that such party will have to finalize and file the documents with the terms identical to or substantially similar to the one stated in the document that would be attached as an exhibit or schedule to the settlement agreement.
Thank you. I also note, while you were speaking about the conditions, one of our participants who practices bankruptcy, which we do not, has advised that if you're making payments, it should be after the 91st day that the payment is made for purposes of bankruptcy. And that's an interesting topic, which is not part of this, but it's good to know.
Yep. Yes, very much. Thank you, Laurie, for sharing that tip on for bankruptcy purposes. And yeah, so it is true that the payments for in the settlement context, they should also be calendared, probably based on other considerations. So here would be bankruptcy. Later on, I'm going to talk about some employment matters. So the payment should be made after a certain time. So this is important also to keep that in mind, and to calendar the payment and their due dates based on that. Well, thank you for asking this question, Robin. I can also now follow, the other aspect of the other headings for the settlement agreement. things that sometimes I see as being omitted in settlement agreements. One of them is an acknowledgement of settlement. So there, you want to have the other party acknowledging and saying that they understand the terms and that it's a full settlement of the claims and that it is adequate and fair. You also want to specify that there's no admission of liability, so that this may not be used eventually later on as against the releasing party. And it might also be helpful for insurance purposes that there's no admission of liability whatsoever. And it's just very often to buy peace or for the sake of avoiding protracted litigation. You can give like this type of reason of why you're entering into an agreement. You are entering into the agreement, but you're not admitting to any liability. Other sections of the settlement agreement would be the remedies. So remedies are not limited to breach of contract. You can be more creative for your remedies, and Robin will be talking about remedies more at length. But for example, one of them could be return of the settlement payment, or other liquidated damages. And I think Robin will be talking about this, but you can be creative about the remedies there. After that, you can representation and warranties. This section, I find it pretty useful. Again, if you have also non-sophisticated, less sophisticated parties, opposing parties, but also you want to have assurances that the opposing party has not assigned its claims, and you may want to include an indemnity there in the event that they have assigned their claims against your company or your clients. You also want to have a representation and warranty that there is no outstanding or future claim, or that the party hasn't filed any type of complaint or claim with a governmental agency. You would like the other party also to guarantee, warrant, and represent that they have the authority to enter into the agreement. Lastly, if there is potential defenses of fraud, duress, or mistake that they may ascertain, then you may want to include some representation for that. Again, it's not always necessary, but sometimes you feel like the person in the opposing side are more on the bad faith, or they may have a tendency to bring weird arguments, and just you don't want to again cut any further exposure to liability. So I would include as many reps and warranties as may be necessary there based on the situation and the context. Another paragraph would be the legal cost. If preferable, the parties should bear their own legal cost, and that should be specified in the settlement agreement. But also you want to include attorney's fees if you have to enforce the agreement, because no matter the underlying theories of the dispute that resulted in that settlement, once you enter into the settlement agreement, it would be a breach of contract. So based on breach of contract, or for example, in California, you don't have attorney's fees for breach of contract unless it's actually specified in the contract. Usually it's going to be statutory or contractual and has to be included in the contract. So here you may want to include an attorney's fees clause, and then we also have confidentiality. So that's an important language, very important part of the settlement agreement, heavily litigated, and Robin will be talking about this in much more detail. And then you have also, so for taxes, you want to also get you want to write how it will be treated, if there are any tax consequences on the releasing party or on the released party, making sure that to identify who will be responsible for this. And then in the miscellaneous, which tend to be boilerplate, this is where, if you haven't updated also your settlement agreements for quite some time, this is where you may want to revise some of these provisions. I think one very important, when you have an agreement that ends up in court or is being enforced and litigated, very often you jump into that section of the agreement hoping to see or not see a specific provision. So it's worth spending some time and effort for the miscellaneous part. Want to make sure to have an integration and merger clause. The merger clause will guarantee that there will be no introduction of parallel evidence that would contradict the terms, We want to make sure that whatever is written in that agreement is the final agreement of the parties. If the dispute that led to the settlement agreement was with a contract, based on contract, and had an arbitration provision, well, you may want to include that arbitration provision in the settlement agreement as well, based on if that's what your client wants. But let's not forget it. It could be expedited. I mean, the reason why they wanted an arbitration provision in the first agreement may be the same reason to include it in the settlement agreement as well. One particular provision I really like to include. So you may know that at common law, there is a rule of interpretation against the drafter for any ambiguities. I like to waive it, particularly, especially when I'm doing like most of the drafting for the agreement. So I like to include that waiver. Also, severability clause. It's very important, especially if you're dealing with a hot area of the law. So for example, employment, where you have many claims that cannot be waived. You don't want to take the risk of rendering the entire agreement unenforceable just because one part is. So having that severability clause will help and prevent a court from ruling that the whole agreement is not enforceable. Lastly, you want to have the governing law and venue. You want to specify this. You want to keep control. You want to maintain control if there is any issue or if you have to enforce the agreement. So specify the venue that is convenient to you or to your client, and make sure to have the governing law and the one of your jurisdiction. If the dispute was based on an agreement that has a different governing law, I don't see it as an issue to have the governing law of the settlement agreement being different. So again, if you have good leverage there, or if you can take a first stab at drafting the agreement, just include the one provision that are convenient to you. Worst case scenario, the other side will object to them and try to negotiate, or best case scenario, then you obtain what you wanted in the first place. So that would be it for this part on the checklist, and for the outline of what I would consider as a good settlement agreement. I'm handing over to you, Robin, for your part.
Thank you, audience. We're happy to talk to you about all these recent changes and hopefully reach a good consensus on the best way to draft confidentiality agreements. As Johanna outlaid all the important segments, my portion of this seminar today is on confidentiality provisions. It was something that I never paid that much attention to in terms of restrictions. I just somehow used to think that if a party negotiated an agreement to keep certain items confidential, or the entire settlement agreement, it was doable because the parties had intended to and wanted and agreed to do it. Problem is, that is not true because it does violate certain laws. Contracts govern settlement agreements. A settlement agreement is governed by contract law. And the irony about the confidentiality agreement or confidentiality provision is that it does not adhere to strict contract law. In other words, contract law says you have to have the party's intent, you have to have an understanding of what it is that's the subject of the agreement, and a willingness to enter into the agreement and abide by all the provisions. So one would think that if confidentiality provision was one of those provisions, you could simply agree that portions would never see the light of day. Well, it's not true. And especially what's caused a lot of this change started in 2017, probably really mostly affected, at least in the beginning, California on the West Coast and New York on the East Coast. And I'm going to name to you at least one of the famous people that helped this come about, even though I don't think he ever realized he would have a great effect on the laws in the United States. And that's Harvey Weinstein. Me Too movement, all the sexual complaints by high-powered entertainment network, anchors, journalists, we can all name several that have come to light, has made a great change in how confidentiality provisions can be used. You just can't decide to agree and draft the provision. If you are dealing with a settlement agreement that involves employer-employee in any industry, and the topic of the agreement is a sexual harassment claim, an age discrimination claim, a gender discrimination claim, those settlements, and at least if there's just a provision, if it's not the whole contract, a whole agreement, those provisions can no longer be kept confidential. There became an overriding public policy that it's not doing the country any favors if we sweep this under the rug and allow that employer to continue, because it's kept confidential, with that bad act and never have it corrected, because the employee is not allowed to talk about it with other employees or with anyone for that matter, except for the accepted typical exceptions of confidentiality, meaning your tax accountant, a subpoena for the court, something along those lines. So for public policy reasons, that was really the driving force. What did not change is trade secrets and IP, protected intellectual property. The basis of the change is really focused on personal matters, race, religion, age, and any unwanted sexual practice, any way you define it, whether it's verbal or touching or just inappropriate writings, comments, jokes. And it happens all the time, but it cannot be, as I said, swept under the rug anymore. The federal government, actually Biden's act, came into effect January 1st, 2022, where the government passed the House Bill 445, ending forced arbitration. That came into play because there are different rules for arbitration, and the fact that the government no longer wants to keep these types of issues, these personal problems at the workplace, covered, glossed over, not discussed. No longer does the FAA necessarily trump a settlement agreement. And that always used to be the case under federal procedure. So it's not only on a state level, it's also on a national level. The government code in California describes it as any act that's considered unlawful conduct. Another area that is no longer to be kept confidential is pay. How much you're being paid as opposed to the person next to you. You cannot get fired for discussing that or disclosing it. That can no longer be an agreed agreement or provision of a settlement agreement of any kind or an offer of employment. The emphasis there was not Harvey, but it was all genders, that females and women's rights were being affected, numerous claims that male counterparts in equal positions were being paid significantly more. So that is no longer a provision that could be confidential. When else can it be confidential? There are a couple of specific provisions. You probably know these. Maybe you haven't thought of them, come across them, but they're good to have sort of a cheat sheet on what can and cannot be kept confidential. And that is one example, class actions. The reason class actions cannot be kept confidential is in order for the pot of money that is being distributed to be distributed fairly, the court has to see the settlement amounts, what's being paid to the class, what the lawyer is accepting, is there any reimbursement to any government agency under PAGA claims. All of that has to be taken into consideration. And so that's why at the very top of this confidentiality, you cannot consider confidentiality provisions for class actions. They will not be held up as valid. Other types of settlement agreements where confidentiality provision will not prevail is when there are settlements involving minors or persons with disabilities. That is for obviously their protection, because the courts feel that with these disabilities, they may not have the ability, the wherewithal to understand what is going on, and they need additional protections as opposed to an adult drafting that agreement. A couple of other ways that settlement agreements, that confidentiality provision will not prevail. And that is when there is a settlement agreement that includes specific facts or acts or details in an ongoing litigation that is relevant to the litigation. The court will overturn the confidentiality agreement if what's being sequestered as confidential is relevant to the litigation that's ongoing, and there are other defendants who are still litigating that chose not to enter into a settlement agreement. So the courts will, for purposes of discovery, state that if it's relevant, it comes in regardless of confidentiality provisions or not. Another interesting factor to consider is who's it confidential between? The signing parties and the attorneys? Well, that was quite a discussion in 2019, one of the seminal cases, California Supreme Court. It's entitled Monster Energy Company versus Schechter, 7 Cal 5th, 781. The form and content, California overturned the recent appellate decision in that case, and the form and content of the attorney's signature block, which is usually the block that the attorney signs under. It's a separate signature block as opposed to the parties that are settling, is not controlling. The court now says that it's the intent. Did the attorneys also intend to be bound by the confidentiality agreement? This, I don't know if you've thought about it, but I used to take this for granted and assumed that if I signed to form and content, that I was also bound by the terms as with a confidentiality agreement and that it could not be disclosed. That can be litigated, believe it or not. If you don't have a separate provision, and Johanna touched on this as well, that's important to you, and you don't have it separately initialed, it could be an area for litigation. And the whole point of the settlement agreement is not to have to go back and litigate the settlement agreement. So it kind of defeats the point. The best practice, probably because these rulings are so new within the last 4 or 5 years, is to make sure that you have a separate provision that is initial. If you have any doubts, your opposing counsel will keep this confidential, especially perhaps if they represent the employee, and it's more important to the employer to keep a certain settlement amount confidential. You may want to have the lawyers also sign a confidential provision, or not have a separate block, or rewrite the block so it says form, content, and confidentiality provisions integrated within the settlement agreement. So you've got to start thinking strategically of ways to avoid going back to your employer and saying, yes, I know I got you a great settlement. This was really wonderful, but there's a problem. We have to relitigate the confidentiality agreement for any number of the reasons that I've already explained, or for the simple fact that one of the lawyers is discussing over LinkedIn, over the internet, the agreement that was reached, even if it's not financial. Now, financial terms enjoy probably the most protection if you're drafting a confidentiality agreement. They serve no purpose. They do not invade public policy. They do not make it more difficult for the ongoing litigation for the non-settling parties. So that is something that you have to think about as well. I hope you've received this. I hope you received our article and our handout sheet. We have a 50-state chart that surveys all 50 states with respect to these new provisions since 2017. I would say in an overview of the chart and from the cases we examined, California and New York lead the way with the most stringent rules. California, Joe Biden's SB 331 called Silence No More Act, which goes back to sexual complaints and personal problems in the workplace. Those protections have been made retroactive to 2017 when this area was brought up to the forefront because of so many workplace complaints on sexual harassment. The important thing about settlement agreements is trying to ensure that the confidentiality portion is important enough that you're not going to have to, that if you're going to put it in the agreement, you have got to find a way that it cannot be open to litigation. And whether it's discovery, sexual harassment, because you did not keep up with the latest statute in Ohio or New Jersey, wherever it is you're practicing, will subject you to litigation. And that's really the point that we're trying to avoid. I have practiced in-house for a Fortune 300 company for 5 years. A lot of my work was settlement agreement. I have practiced 25 years in litigation, and a lot of my work is settlement agreement. I think any litigator knows the one statistic no one seems to forget: 95% of the cases settle. So I found that between being in-house counsel or being in a law firm that represents all kinds of clients, that it is really important to make sure that you're up to date. It's very little difference from when you're litigating or you are just settling a grievance between an employer and employee. The only difference I have found is that if you are litigating and you're not in-house, then chances are you have to be much more aware of the discovery, what facts you have put into that agreement, so that a court will not order it to be exposed as a public record because they need the facts, because they're relevant to the rest of the non-settling defendants. It's really important. Okay, well, there's so many exceptions. What can we do if we cannot draft an acceptable confidentiality provision? Parties can't agree to one, myriad of reasons, certain restrictions with that particular state law or that venue or jurisdictional. Any of those reasons come up to complicate it, and it becomes just unwieldy, too complex, or just fraught with problems. What you can do is move to have your settlement agreement sealed. This also is not necessarily easy because there is, and I think this is true coast to coast and everywhere in between, there is a great enforceable public policy that says it's really important for the court to know, for the court to have access to filed records, to not be in the dark about what is going on. I think that is why the news, trials like Johnny Depp just recently, whatever the subject matter, it's open to the public. There's more televisions, and courts really hesitate to taking that away from the public's right. So if it's a matter that's important fighting for, you're going to have to convince the judge that the damage without sealing the record, the agreement, will be greatly damaging to one or both parties, that that interest outweighs the public's interest in needing to know what's in that agreement. And you cannot come in and state, well, we just don't want the amount of money we paid Mrs. Smith to become public. It was an unusual situation. We will never pay that amount. That does not work. When they say you need a specific reason that's tantamount to privacy, such as financial privacy. If you can't get all the records sealed, you can at least argue to get certain portions sealed. So if it's not the whole agreement, maybe it's just the financial portion. But you're going to have to convince the court first that trumps the public right to know. When is a confidentiality, how broad should it be? Well, first of all, if you're carving out a separate confidentiality agreement, it should be defined and narrow. At the point that it's so broad that you're throwing in the kitchen sink, you are just better off asking to seal your document with the court if it's that important to you. I just happened to pick up a question. I'll just take that briefly before I go back. It is not, a protective order is not the same as sealing. A protective order could be filed, well, it's signed by the judge, so it's filed with the court. Judge will typically have to approve a protective order. So you have to make, for sealing the records, a separate motion and focus your legal research on cases as to why there will be significant damage outweighing the public's right to know. I do not believe that a protective order, because it is signed by the judge and part of the record, will be acceptable to give the kind of protection that you're looking for when it really matters. There's some things that it might not matter as much, and you want to think if it's even worth drafting a confidentiality provision for that, because again, the goal is not to have any provision challenged, not to have the litigation continue, and to make your employer happy that, look, it's a good deal, we got it done, and it's foolproof. So got to be careful. I would limit the scope to what's really important. And by that, look at the foreseeable results. What will happen if this fact, term, dollar amount gets exposed to the public? And from there, if you start off with that mindset, you can narrow your scope, make it more tightly written so that it's subject to less challenges. If it's confidential, it's never part of the record. You want it part of the record, then no, it's not going to be confidential. We've talked about written agreements so far, but certain courts will accept oral agreements. They're more prevalent, I think, with the Ninth Circuit, the Western states. Best practices for oral settlements: sit down, have the lawyer put down the writing, just as if you were the mediator or an arbitrator. Put down the writing, the terms of what the parties agree to, what they will agree to, any matters that are conditioned, all events, times of payments, all the material portions. Have the parties sign it, have the lawyer sign it, and then have the judge read it into the record. It then becomes a part of the record. Another way that a settlement agreement comes to be part of the record is when the settlement agreement is attached to a dismissal. One of the things you can do is work with your opposing counsel and say, well, listen, we've pretty much figured out that these are the terms we're going to do. Let's write this up and we will just file it with the dismissal of the action. And that's great for the court. They have those documents together. It is part of the court record. And even though it was orally described, it was then written and then transcribed by the court and part of the court record. So there's nothing to create a he said or she said with those cases, with oral agreements. Oral agreements are not always acceptable. Depends upon the jurisdiction. And that is something that if you find yourself in that situation, you need to check what the rules are for your specific state. I believe, if I recall correctly from our 50-state survey, that Arizona and Louisiana may not allow oral agreements. But you might find yourself in a situation where if you don't strike now, the parties are together. Do you think you've worn them down? Both attorneys have worn them down where they could see the day of light, that this is the best resolution for each of them. You might just stand up and say, Your Honor, we've reached a settlement. We're asking you to put it on the record. We have not had time to write it up. And certainly California, New York, but any jurisdiction that allows it, you have all the terms. They're in the transcript. They're written up. The judge puts on the record that this, after asking the parties if they have willingly agreed to the settlement, and it's as good as a written settlement had you spent a week drafting it. So there are times where it's just a matter of necessity, even though, as Johanna reminded us, careful planning is really the preferred practice. When is a confidentiality provision not important? Well, then it shouldn't be in there. If there's a confidentiality provision that does not matter, that will not cause harm, leave it out. Don't raise it, don't cause attention to it. Confidentiality provisions have lost a lot of their purpose. Their purpose usually was to protect the employer's reputation, and keep hush. Well, basically what the employer often thinks of as extortion. But now with our personal rights becoming more important in terms of the public's perception and public policy, where all these changes have taken place regarding personal liberties, how much do you make, sexual acts, any unlawful act, employee to employee, employer to employee, you are better off drafting a confidential agreement if you can. But if you're just putting it in there because, well, it's not unlawful conduct, I can do this, I prefer that the parties to the agreement do not discuss this, you may open yourself up for some challenges that you do not want to deal with. And if it's not critical, I would kind of change that to not important to not critical, rethink it. And lastly, for this segment, I just want to briefly touch on non-disclosure agreements. Non-disclosure agreement is basically a confidentiality settlement. The whole thing is confidential. It also brings up another way that if you think your confidentiality settlement agreement, that provision is going to be challenged, leave it out, draft a separate non-disclosure agreement to protect. They're typically used for intellectual property, trade secrets, vendors, customer lists, certain items that have economic value to you that you, when the employee leaves, regardless, they stay as a forever employee and they're a 25-year employee, that's all great. But part of keeping a trade secret is that you've taken protective measures so that it is not publicly disseminated. Well, you may have one employee, for instance, let's take Tesla, one employee working on driverless cars. Okay, and there are trade secrets. They're developing new source codes, new types of technology to deal with some of the kinks and some of the problems from prototypes. And you really don't want that employee discussing it with another employee who perhaps is in the environmental division and studies matters how to make electric cars or gas cars more efficient, less pollutant. Point is that they don't have access to those documents, the company's manual, whatever that contains, that all important economic information, that employee doesn't share it with other employees. It's a lot easier to defend and protect when you don't make it available to all employees to discuss and speak about it openly. So you want to consider that. Could be a small business as well. I recently have come up with, it relates to dog grooming services. Believe it or not, they have trade secrets, and there has been a recent case where the confidentiality provision became an issue because one defined it as a trade secret, the other did not. And besides looking at the economic factors, we had to factor in, could this be discovered anywhere in the public domain? Should it be anywhere in the public domain? And if you find that it's protectable, again, your best method may be a non-disclosure agreement, and either separate or incorporated into the settlement agreement as a second agreement. That is all I have for the portion discovering confidentiality provisions. They're crafty, they're new, really important to study that. I think it's the area for settlement agreements that has changed the most, especially as we've been talking about personal liberties.
I think someone asked a question about disparagement clauses. That's Karen, about our thoughts on this. I would include them. I would make them narrow enough so that they're still reasonably narrowed down to the reputation of the business or any other communication that you want to restrict. I they're enforceable. But I mean, depends on the jurisdiction. But I include them in my settlement agreements. I make them narrow down so that if one day they end up in front of a judge, they don't seem unreasonably broad. But I include them. And sometimes just even if something may not necessarily be 100% enforceable, just because it's there, it might actually incentivize the other party to comply with it. Not that it's like the best legal advice there, but when it's written, people might tend to actually comply with the provision. So moving on here, the second part, I wanted to give some tips for different types of settlement agreements. The first one is like employment. As in-house counsel, we assume, oh, you're welcome, Karen. We assume that you probably have to deal with employees and settlement dispute. And so upon preparing this presentation, it became clear that in your settlement agreement, and more particularly in the waiver part, you want to make sure if it's a general release, not to waive claims that cannot be waived at law. So you want to include a carve out that clarifies that the release does not and is not intended to release any claim that cannot be waived or released as a matter of law. And that way you're limiting the risk of the entire release being unenforceable. So while the statement that I just mentioned may not be sufficient, you may also specify which claims are not going to be released. So for example, it will be the Fair Labor Standards Act, which needs the Department of Labor or court approval for the waiver there. So you may want to specify this. Actually, for the Fair Labor Standards Act, you can include a representation that does not expressly waive these claims, but instead condition the agreement on the employee's verification that the employer has paid him all the wages owed for all hours that the employee has worked. So it's not fail-safe, but that might just strengthen the employer's position here. Also, you can also specify that the waiver, the release does not include prospective family and medical leave or whistleblower award under the Dodd-Frank or Sarbanes-Oxley Act, and so on. I wanted to bring some spotlight on the Age Discrimination in Employment Act, and especially for workers or employees who are 4 years of age or older. And there's this Older Workers Benefit Protection Act that provides requirements, specific and strict requirement as to what the waiver or the release or the settlement agreement has to include to waive the ADA claim. And there are actually a few requirements so that it constitutes a knowing and voluntary waiver. So the first one, the release has to be in writing. So what Robin was mentioning about having some jurisdiction oral, the settlement agreements, well, for this type of claim, it has to be in writing. It has to be understandable by the employee. And there the standard is that the document has to be geared to the level of comprehension and education of the average employee receiving the severance offer. The waiver also has to expressly spell out age discrimination in Employment Act by name. It cannot include future claims, and the consideration has to be more than what the employee is entitled to. There has to be a statement that the employee is advised to consult with an attorney before signing the waiver. And you need to give the employee adequate time to consider the waiver before signing it. If it's individual employees, 21 days. If it's group, or if it's like part of like a group termination program, then it has to be 45 days. Now, the thing is, like in any event, this type of waiver must give the employee 7 days to revoke their agreement. And that's something that cannot be waived. So when we're talking about when tendering payment for settlement, well, in that case, you want to tender payment at the expiration of that period. So you don't find yourself in a situation where the employee has already cashed the check and then decides to revoke their agreement, the release, based on this statutory rights too. So you may hold on to that or give the agreement to the employee, telling them that they have 7 days to sit on it, think about it, and within 7 days, then they will receive their settlement or severance payment, whatever the payment will be. Also, for your employer, for your client employer, you may want to, if you have a returning employee, so if you have a settlement agreement or a dispute being settled with a returning employee, you may want to think of having guidelines upon their return. What kind of information they can discuss with other employees, and what cannot be said. If there is a question, to whom should they talk to if they're not sure if that information can be disclosed, or is it part of a confidentiality provision of the settlement agreement. Give them guidelines. That would be really helpful. That will just ease the process of returning employees. The last tip I have for employment agreements is the tax consequences. You may want to know that for employers that settle claims alleging sexual harassment or abuse, if the settlement agreement includes a confidentiality or non-disclosure provision, so clearly not California, as Robin mentioned, but you cannot take the company cannot take a tax deduction for that settlement payment. So that actually could be a big consideration, whether to include a confidentiality provision. If it's not that important, well, it may end up in a pretty big tax bill. So that's it for the tips for employment agreements, settlement agreements. I have a few others I want to share for torts. What happens if you have multiple defendants and only one of them settles? So you may want to check with your jurisdiction if the common law still applies. At common law, the release or dismissal of one tortfeasor would release all the others. So once the injured party has been paid by one of them, the cause of action is satisfied and cannot get or collect any more damages from the other parties. So in California, that common law is no longer applicable, and the settlement discharges the released party Sorry, let me just go back. First of all, the settlement amount, it only reduces the plaintiff's recovery, so that any further recovery will be reduced by the amount previously settled. But also the settlement will discharge the released party from from other liability by contribution. So if you're representing the party, the releasing party, if you're representing the released party, and you want to give your client extra confidence that their legal exposure to liability, or that there might be like future claim for contributions, that these are extinct, you want to, for example, in California, we have a good faith settlement determination. So that would be a court procedure that will bar any other tortfeasor from claiming damages or making contribution claim against your client. So I don't know if these exist in other jurisdictions, but it's a powerful tool to just be done once and for all with a particular claim. And then lastly, just like a don't forget list, if you want to minimize the risk of rescission, so that will really depend on the position of your client. If your client has more knowledge of material facts of the dispute, or the other party hasn't conducted full discovery, you may want to mitigate the risk that the less knowledgeable party brings a claim to rescind the settlement agreement based on the fact that they did not know the material facts. So you may want to include something to the effect that the opposing party would represent that that they had an opportunity to investigate all the facts that they deem material in entering the settlement agreement. They acknowledge that the other side may actually have more, more knowledgeable about the facts, or may have better access to material facts, and that they're like willing to forego their opportunity to conduct discovery, and that this settlement amount is fair and square. You may want to include something like that. That's not fail proof, but that might give additional like a strength. That will give a stronger argument for your client. On the other hand, if your client is actually the party who lacks information, you may want to protect your client from non-disclosure of material fact. So if the party that don't have a duty to disclose certain facts that are damaging to them, but you may want to add something to the extent that each party has accurately and truthfully disclosed all information that has been requested, and that they fully fulfill their duties to disclose, if any. That might just give us a bit more strength also to your client, or maybe peace of mind if they're worried that they're missing key information and the other party was not very truthful. Also, for tort claims, if you want to minimize the risk of rescission claims from the other side, you may want to add in the release consider adding something for fraudulent inducement so that any fraudulent inducement claims are included in the claims being released. And the reason is because up to the date of this, until the date of the settlement, everything will be released up to that time. So that would include this type of claims. Don't include a provision that will prevent the other side's attorney from representing similar claimants. That would be a violation of ethic rules. For example, 5.6b, I think these are the model rules. The lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. So that's something try to keep in mind and don't include this type of clause there. Lastly, you may consider the cooperation and non-cooperation provision. If you want to have the other party, if you want the party to not cooperate in the private sector with other potential claimants, you can include that clause there. That would be enforceable to the extent that it's prohibits voluntary assistance in private litigation, but that would not be enforceable to prevent disclosure pursuant to a valid subpoena or for ongoing investigation by public agencies. Also for a cooperation clause that if your client has lost something or the opposing party has infringe or certain rights, you may include a cooperation clause to make sure that the other party will cooperate with your client if they need to execute or file certain documents, or if there's certain action has to be taken to restore the rights of your client. So that's something you can include in the settlement agreement. And again, it would be the ground for a breach of contract, or at least it's a ground, or it would be an incentive for the other side to cooperate with your client if at least it's written in the settlement agreement. Lastly, don't confuse a covenant not to sue and a release. These are in effect, they are doing the same thing, but a covenant not to sue does not extinguish the rights of the party, of the releasing party, but it just merely gives the other side a contractual claim. And if you want to make sure that the other side no longer has the right that they were claiming against your client, then it's really a release that you want. Covenant not to sue is really, it's a contractual theory. So that's it on my end for the tips for different types of settlement agreements. And I'm handing over to Robin for last part. And I think we have a poll before the last part.
Yes, and the poll is up. Johanna, while we're waiting for the results, I wanted to ask you, you were discussing tort feasors when there's more than one.
Yes.
Well, is that the same thing as the Mary Carter provision, or is that something different? Is Mary Carter provision still in something we're using, or is that outdated? Do you know?
So the Mary Carter agreements, it's a little distinct. They are banned in certain jurisdictions, such as Florida, Nevada, Texas, and Oklahoma, I believe. And they're a side agreement. So where you have one of co-defendants enters into an agreement with the plaintiff, they agree on an amount that selling defendant will give to the plaintiff. And in exchange, that defendant remains in the lawsuit. This plaintiff agrees not to enforce a judgment against a selling defendant. They're not used that. I mean, I've never used them. And I've never, I don't have any opposing counsel ever proposing to use, I've never heard of any opposing counsel using this with their clients either. So they're not per se illegal, but as long as they're adequately disclosed, which might defeat the purpose of them if they were meant to be done on the side secretly. But yeah, they're another entire hot topic that I didn't necessarily want to disclose to talk about this now because, well, we're limited in time. So 84% did not have to litigate their settlement agreement. Well, that's great. It was a great settlement agreement then. For 15% had to. So, well, perfect. That's a great transition into the next topic.
Thank you again, Johanna. Yeah. 85%, that is terrific. I would say that in my years of practice, I would say I'm about there as well. I've been fortunate. We have not gotten too many over the years settlement agreements that were wrecked and had to go back to litigation. Here is some tips if you do have a problem and what you might want to do about it that may ease the burden when you have to tell your client, great settlement, but we got a breach. Somebody didn't follow the rules. Before I actually tackle that, I would just like to go back to the confidentiality provision and give you one more point that I had written down in case it's of help to you. The federal laws, Ninth Circuit at least, 29 USC section 626 subsection F, state that when it comes to discovery, that confidential provisions will not necessarily hold up if the discovery is relevant to the ongoing non-settling litigants that remain in the case. That we discussed before, but I wanted to give you the site and let you know that there are still a minority of jurisdictions that say that FRCP, Federal Rules of Civil Procedure 408, govern and all settlement agreements are protected. Again, be very, very careful because it has changed so much that you need to look at your jurisdiction and make sure you follow the rules. One thing that I don't believe has changed at all regarding confidentiality is mediated settlement agreements. By that, I mean the mediated settlement agreement can be confidential, but was always confidential is the discussions that led to the writing of the settlement agreement. That is still protected, hasn't been changed, and that is true in the context that where we have personal liberties at stake, such as sexual harassment. That has not changed due to public policy. Courts really feel that if the parties can settle, all the better for them. And the only way to encourage people to settle is a safe, confidential environment. Rules on mediation protection, at least in the Ninth Circuit area, have not changed. Okay, well, what if we're in that 15% where, oh my God, I've got to litigate, got to tell the boss that it just didn't work out. And we just couldn't rely on the other side to do their part. The most common way that I know of is a liquidated damage clause. The only interesting thing about this part, or else it would be simple, you would just put in a number, is that you need to avoid a penalty. What makes it a penalty clause as opposed to a liquidated damage clause is that it's unenforceable, meaning in short terms, it is a sum that does not reasonably relate to the issues that were being litigated or were being settled. You cannot just come up with a number because your client was put through the mill, had attorney's fees bills that came in close to 7 figures. You cannot just make up a number for liquidated damages. One of the easiest kinds of contracts that you can avoid running into a penalty is construction contracts. And the reason is usually in a construction contract, the general contractor will contract with the homeowner to state that if they deliver late as opposed to the date of completion, that there's X amount of penalty, or we should say charge, X amount of charges per day that they incur by having to be delayed. Those charges per day can be multiplied by a period of time. They're a month late, 2 months late on the contract, 3 months late, and you have a rational number, a number that relates to what you will be damaged if the settlement agreement is breached. And obviously you don't want to relitigate what the facts in terms of what got you to the settlement agreement, but you want to make sure that it will be a sum that takes away the pain from having to tell your employer and whoever your client is that there's been a breach. At least that way they'll feel protected. Another very common area this comes up in, and most of us is if you bought a home or sold a home, you'll see it in purchase and sale agreements. They are carved out, liquidated damage provisions are carved out as separate provisions requiring separate initials by the parties. They make it very clear that if you agree to this, you have agreed that it's a reasonable amount that you are willing to forfeit. You understand you will forfeit if there's a breach in the settlement agreement. That is one way of doing it. The measure of the damages, if it's not something readily available, say construction project that's delayed, rentals that you cannot rent out, the rent per day, if it's not something that's easily defined, you can be somewhat creative as long as it's rational to relates to the disagreements that led to a settlement agreement. Often for real estate agreements, they use the buyer's deposit for a liquidated damage clause. There's a presumption that it is reasonable because deposit was reasonable. It represents the time that the home was off the market, the cost of marketing, having to be remarketed, and it's easier to defend and not run afoul and end up with a penalty clause. The measurement is done at the time the contract was made, meaning the settlement agreement was executed. It's not made, and you cannot value a liquidated damage clause at the time of the breach. And that also helps assures that it had some rationale to the damage that person who suffers the breach will be forced to incur. I think that is pretty much all we have on liquidated damages. And lastly, if you do have a situation, there's great concern that the other side may breach, as long as you believe they have the wherewithal, put in an attorney's fees clause. If you think your client's going to breach, maybe you want to rethink that. Just depends upon the parties, that particular agreement, but it could be used to help prevent someone from breaching agreement, or at least making them think twice about it when they see an attorney's fees clause added for the breach. And I thank you for your time.
All right. Great. So a couple of things. Thank you, Robin and Johanna, for a expansive, informative, engaging presentation. Folks, if anybody has any questions for the panel, please put them in the chat. We've got some great rounds of applause coming in from the chat, so thank you. Keep it coming. There was a question in the chat. I don't think we got to it, and I got actually a question by email. So I want to clarify. One of the, I think it was Lori, she mentioned wonderful, wonderful applause. Thank you, audience. Our panel worked very hard on this, so keep it coming. And so I just want to clarify on the 90 days, right? There was a comment about a 90-day clawback, and basically, if a party to a settlement agreement makes a payment as part of the settlement and then files bankruptcy within 90 days of payment, that payment could be the subject of a clawback. So I think she was saying make it payable on the 91st day, so it's not subject to a clawback. That's great advice. There was a question about non-disparagements. Robin or Johanna, do you have thoughts on including?
Yes, it was Karen, and I've addressed, responded to
Okay.
this. Yeah, to say like to include it and have it like narrowed down to something that would not be deemed unenforceable by a court.
Okay, sounds good.